For antiwar.com, I'm Scott Horton. This is Anti-War Radio. All right, second guest on the show today is the other Scott Horton. He is a distinguished visiting professor at Hofstra Law School, a journalist for Harper's Magazine. I believe that's the oldest continuous circulation political magazine in America, where he writes the great blog No Comment at their website, harpers.org. And he is our regular number one expert guest on the issue of the Bush-Cheney torture regime. Welcome back to the show, Scott. How are you?
Hey, great to be with you.
I'm glad to have you here. So there's a lot to catch up on since we've last spoken, which was just a couple of weeks ago. But let's start with today's news. An FBI agent named Ali Soufan, if I'm saying that right, testified before the Senate Judiciary Committee about his experience and what he learned from his participation in the interrogation of these al-Qaeda suspects. Please catch us up on what happened this morning.
Well, indeed he did. Ali Soufan is someone, a very, very big name. In fact, a lot of us who've been covering this area, the counterterrorism area, have tried for many, many years to get Ali Soufan to come on record, give interviews, and so on. And that's because the FBI basically constantly held him up as a trophy. He is the best of the best, their number one star interrogator on this issue, the guy who was sent in the most difficult of circumstances and constantly came back with results. And so he gave a pretty lengthy description of, his involvement post 9/11 with some of these high-value detainees, with a special focus on Abu Zubaydah, of course, a figure who has been front and center in the torture memoranda, and also in this narrative that we're hearing from our former Vice President, Dick Cheney, who's all over the country now on television talking about the Abu Zubaydah interrogation. So I think some of the most interesting nuggets that came up from his testimony had to do with that particular case and the successes he scored in interrogating Abu Zubaydah. And then he says he was forced to turn Abu Zubaydah over to the CIA, and they started using the rough stuff. And that's where the process of gathering actionable intelligence stopped.
It's so strange to me that all this stuff that is coming out now is all stuff we've been talking about on this show forever. I mean, all this was in Jane Mayer's book, The Dark Side, 2 years ago, right? Or a year and a half ago?
Yeah, about a year and a half ago, that's right. But now we're seeing the, visual confirmation, we're seeing the documents, and we're getting the witnesses testifying live. By the way, it was a little dramatic. I was in the hearing room this morning, and Ali Soufan was sitting there at the table testifying, and he said, no cameras on me, please. So the camera remained panned off on the side of the table whenever he was speaking. Because, of course, he's, I think, he's been a focal figure in the counterterrorism campaign, and he's anxious about having his mug be identifiable out there.
And now, so tell us about these psychiatrists that the CIA brought in. Who are these kooks? What are their names? What are they about here? Was this B.F. Skinner gone mad now?
Mitchell and Jessen are the guys who are involved. They're based up in Washington State, and they had a track record of working with the SEER program. That's a special program used to train pilots and special services personnel in the resistance of torture techniques if they should be captured. And the SEER program for many years, of course, the U.S. during the Cold War and prior engagements, we identified our enemy as North Vietnam, North Korea, Communist China, and Russia. So the program studied the torture techniques that were used by those communist governments and trained these people to resist. These two psychologists were hired to reverse engineer the SEER process to devise torture techniques to use on prisoners held. So, of course, all they did simply is take the communist Chinese and North Korean techniques and adopt them as U.S. techniques.
Well, now, is there any question at this point, sleep deprivation and long-term shackling and all these things, is there any question, I guess there still is a question, to motive, whether Dick Cheney and Scooter Libby sat there and decided, David Addington, whoever, and said, listen, we need lies that implicate Iraq, let's start a torture program and we'll be like the Soviets and we'll get lies out of people by breaking their will with torture.
Yeah, indeed, all the studies that we did from the Korean War era, there were two major studies prepared, one by the Air Force, and those studies said that was the principal purpose of the use of these techniques. It was to get American airmen to lie, to get them to make propaganda statements for the Communist Chinese. Never had anything to do with getting the truth. And indeed, these techniques were very, very effective at getting people to make false statements, no doubt about that. And I'd say that track record continued unabated when the U.S. used them. Same process. And in this case, when we look at the new Senate Armed Services Committee report about when these techniques were put into play, we see there are two periods where there's a big spike, a great number of applications, and those are roughly 3 months prior to the invasion of Iraq and just after the invasion of Iraq. And the reason for the spikes, clear enough, it was to get statements that could be used to justify the invasion, and then after the invasion, to get information that could be used to justify claims that there were weapons of mass destruction or nuclear programs or biological programs in Iraq.
Well, forgive me, Scott, for skipping to the end of the interview here, but this really cuts right to the heart of the question for me, and I know that you lawyers are really passionate about this kind of thing. But is there such a thing as the law at all, or is this really just a big joke, right?
Well, that's, I think, the upshot of what the Bush administration did. In law schools, we talk about, or in legal philosophy, we talk about something called legal indeterminacy, which is a fancy word that says, well, everybody can have their good faith subjective understanding of what the law is, so objectively, there is no law. And what happened here is, we had a very clear-cut criminal statute that said you can't torture somebody. And here, the Bush administration went and got a bunch of lawyers to write memos basically defining torture into oblivion, so there really wasn't any such thing as torture. They said, we were relying on those opinions, so therefore you can't accuse us of having violated the law. This was an exercise in Alice through the looking glass, effectively. And what they're doing really is they gutted the prohibition on torture, because any government around the world can use this exact same technique. Bashir, the dictator in Sudan, can use it. Hugo Chavez in Venezuela can use it, and Putin in Russia can use it. They can all just have their lawyers write them memos saying that whatever it is they're doing isn't torture.
Well, now, and I know you've been the chair of the New York Bar Association Committee on Human Rights and I think international law, too, and you're a real expert in all these laws of war. Correct me if I'm wrong here. These laws are very, very specific. I mean, right now, regardless of any particular U.S. law, the conventions that America are part of say that Barack Obama and his Attorney General and the rest of them are, at this moment, felons guilty of conspiring and aiding and abetting and covering this up after the fact. They are required to prosecute these offenses.
Well, that's the clear cut that they're required to investigate these offenses. So there are two sections of the Convention Against Torture that say if there's credible evidence that torture occurred, a criminal investigation has to be opened up. And in this case, we had the president saying that torture occurred. We had the Attorney General saying that torture occurred. Even in the Bush era, we had Susan Crawford, who, was a Cheney crony who was put in charge of the military commissions. Even she said that torture occurred. But there's no criminal investigation going on. So there's definitely a clear-cut breach of these conventions right now. I think really no doubt about that.
Well, and here's the other thing, too. Murder. And I forgot exactly, but you said something to the effect on your blog of like, hey, there's corpses piling up here. It's getting really hard to ignore the crimes that took place. Our friend poor Dilawar, the taxi driver in Afghanistan, never did anything to anybody, was beaten to death in their custody.
Well, that's right. And in fact, the newspapers these days and the broadcast media tend to talk about this issue in terms of what some lawyers wrote in their memoranda as if that were the crime. Now, those lawyers may be involved through aiding and abetting liability in a crime, but writing the memos per se was not the crime. The crime was when Dilawar, the taxi driver, was tortured to death, or when Al-Jamadi, the famous Iceman from Abu Ghraib, was tortured to death, and indeed, or General Mahoush, who was also tortured to death. I mean, we've got roughly 36 cases of people who died with the death being directly connected to the application of these interrogation techniques. And so those homicides are the crimes, or, cases in which people were physically tortured. Those are the crimes. And then you have to investigate back and see, what's the relationship between the crime and those who authorized it. And that's where we see very, very close, immediate connection with the memo writers. In fact, we can call it sort of a torturer's tango, because when these memos, we first learned about these memos in 2004, remember John Yoo was up front immediately saying, well, this was just us giving our theoretical advice about the law. We had no involvement whatsoever in decisions to actually torture anybody. And that was a lie. I mean, we now know, based on the documents that were released on the 16th of April, that there was a torturer's tango going on. That is, they were writing with respect to specific individuals what torture techniques could be applied to those individuals, with full knowledge that whatever they authorized would, in fact, be done. So there's a direct connection between the torture memo writers and the torture that was applied.
Well, the biggest red herring, I think, about all this, other than it works, which I can't even believe is a real debate, but it's that this is only for Khalid Sheikh Mohammed, who, after all, is, guilty as hell. And who cares about him? And what if it was Osama bin Laden? I don't know how many times I've heard this. You're against torturing Osama bin Laden if you could save an American city from being nuked and all these things. And yet, correct me if I'm wrong, Osama bin Laden is still free. And what's happened here is I don't know how many people have been tortured instead. And I'm thinking back to the Frontline on PBS called The Torture Question. And they featured an interview there with an Iraq veteran named Tony Lugaranis, who said, man, we tortured everybody. I mean, you tell me, Scott, do you have even a ballpark estimation of how many people were subject to these kind of so-called techniques under, the Bush administration during this terror war?
Well, we could go through the different techniques. I'd say with respect to waterboarding, it's a relatively small number of people. Mm-hmm. They claim 3. I'm suspicious that it's more than that, but it's still a relatively small number. But when we look at sleep deprivation and the use of stress positions, we're talking about many thousands of people, upwards of 4,000 people. And those are torture techniques. So certainly we have a few thousand people who are subjected to some form of torture, and we have a handful of people who are subjected to the most severe forms of torture. But I think the point to make here is that we look at modern history. Whenever people use torture and they face some public backlash, the same technique always gets used to defend them, which is point to the victim of the torture and say, this is a horrible, vicious man. He belongs to some reviled ethnic group or some reviled religion, or he's a criminal or something like that. But frankly, my concern is not for the specific victim involved here, the Khalid Sheikh Mohammed or whatever. It's for the integrity of our system, because when these techniques are introduced, they become a lowest common denominator very quickly, and they wind up being applied to hundreds of people, thousands of people. They wind up being applied to U.S. citizens. And indeed, in this case, many of these techniques were applied on Captain Yi, who was an Army officer who came under completely false suspicion of having collaborated with some of the prisoners at Guantanamo when he was serving them as a chaplain. And completely bogus, false suspicions. There was no problem with him and what he did. and he was tortured. And Jose Padilla, an American citizen, was tortured using these techniques. So this promise that they make that it would never apply to an American, bogus. No, I mean, there was a quick reach to use what people felt was the most powerful medicine on anybody who was held in captivity.
Mm-hmm. Well, and Padilla is an important tie between Zubaydah, who apparently, according to this FBI agent Ali Soufan, identified Padilla before the CIA ever got their bloody mitts on him, and he was coaxed into pointing the finger at Padilla. But Binyam Mohamed, which is another important legal case going on in Britain right now with explosive breaking news that I can scarcely believe when I read it with my own eyes, he was tortured as well, including with a razor blade, into accusing Padilla of being part of a plot with him to explode a radioactive dirty bomb in this country, which was the original accusation that John Ashcroft announced from Red Square, I think it was, in Moscow, when they first turned him over to the military in the first place.
Yeah, John Ashcroft announced that in the lobby of the Radisson Slavyanskaya Hotel, and I was standing 10 feet away from him when he did it, watching it in amazement. Yeah. But, yeah, you're absolutely right. The Binyam Mohamed case, we've had some amazing developments in the last 24 hours in that case. And the British court wanted to release a chronology of what happened to Binyam Mohamed. The U.S. government, intervening with the British High Court, is insisting that they not publish the facts that they have about what happened, saying that this is classified intelligence material and that the public is not entitled to know. And, of course, what we're talking about here is a specific description of what was done to Binyam Mohamed when he was held in Pakistan and then later in Morocco. And the response of the U.S. government is that the public doesn't know where this occurred and what foreign intelligence services were involved. So allow me to repeat, it was in Pakistan in the custody of the Inter Service Intelligence, ISI, and then in Morocco, in fact just outside of Rabat, in the custody of Moroccan state security. The public definitely knows exactly which countries and which intelligence services were involved. That's already been published in newspapers all around the world. So this idea, this suggestion that the Obama administration is making now, that this is a secret, so this information can't come out, is ludicrous.
Well,
it's not a secret.
And worse, they're telling the British that, if you do release any of this information, we just won't share any information we have about terrorist threats to your country anymore, in basically plain English. I mean, that paraphrase is not hyperbole. I read it yesterday on Glenn Greenwald's blog.
That's correct. They make a direct threat to Britain of non-cooperation. They say, if we get information about terrorist attacks with you, we may not share it, which of course would be a breach of our obligations to Britain, not sharing that information. So it's a pretty outrageous document. I mean, I'd say the Justice Department statement that is submitted to the British court is a false statement. It's an official false statement issued by the U.S. Department of Justice to a foreign court.
Wow. The other Scott Horton for Associate Justice.
Well, I don't think that's going to happen.
You got my vote. All right. Let me change gears here to the murder. Let's not be coy. He was murdered. Sheikh Al-Libi, who was tortured back in 2002 into providing talking points for Bush's Cincinnati speech and Powell's UN speech about Saddam Hussein teaching Al-Qaeda how to make chemical weapons to use against us and, in our jammies in the middle of the night with no warning, I'm sure. He has died in his cell, hung himself from the ceiling, I think they're saying.
That's exactly what they claim. As I noted, he was an inconvenient witness. The Bush administration desperately wanted to get rid of this guy, just cause him to disappear. In fact, remember back on September 6, 2006, when President Bush made this dramatic statement in the White House about turning people over to Guantanamo, we looked at the list, and where was Al-Libi? He had been held in a CIA black spot, but they didn't bring him to Guantanamo or bring any charges against him. Why? Not because he wasn't one of the most important of the Al-Qaeda conspirators, he was, but because he had information that would be extremely embarrassing to the Bush administration. And that is basically how he was tortured to make a bogus case to invade Iraq. He was, and this is in the months just before the invasion of Iraq, he was held by the CIA. They took him to the Egyptians so the Egyptians would torture him, and they pressed him for days for information, as they were torturing him, for information that would tie Al-Qaeda to Saddam Hussein. And under pressure, under torture, he said, yes, Saddam Hussein was training Al-Qaeda agents in the use of chemical weapons. And Colin Powell went to the Security Council of the United Nations, made that a centerpiece of his case, basically justifying the invasion of Iraq. And, shortly thereafter, that was retracted by the CIA. It was acknowledged to be bogus information. Bogus, of course, because it was obtained under torture. So, he was going to tell them whatever he thought they wanted to hear, and they wanted a case against Saddam, so that's what he gave them.
Larry Wilkerson on this show, who is Colin Powell's aide, basically, I think, swore that he was standing right there and that George Tenet just outright lied and swore to he and to Colin Powell that this is true, this is good intel, you have my word on it no matter what.
And, by the way, this is when George Tenet runs around saying, we got great intel using torture techniques. This is what he means. And it was completely false.
Right, and this is from the guy, again, who said that in his own defense, that when he said this is a slam dunk, Mr. President, he was not saying it's a slam dunk that the weapons are there. All he was saying was it's a slam dunk, Mr. President, that this is enough crap that you can lie the American people into war with it.
Well, I think that's right. I mean, I think one of the big questions that we've got right now in the torture debate is, did the reach to torture occur in order to invent or fabricate evidence that could be used to sell the war? And I think when we look back in retrospect, it's hard to come to any conclusion other than that. They wanted to use torture techniques because that would get the Al-Libis of the world to say, oh, yes, Saddam was working with Al-Qaeda. Turn off the electricity. And, of course, it wasn't true.
Well, and see, here's the thing, too. We get into what Nancy Pelosi knew. Of course, this is a Republican talking point. As long as somebody told her, then that makes it legal. Like if Bill Clinton agrees, that's what makes it true. I love these Republicans. But it goes to the question, again, of whether there could ever be a prosecution here. I mean, we're talking about locking up members of Congress, members of the last administration, and that's just not going to happen, right?
Yeah, sometimes I worry about the sanity of some of our Republican leaders. I mean, because Pete Hoekstra is the guy who's been running around, and Darrell is, making these charges, Pelosi knew, so that's the end of it. But, of course, the big question in the background is whether there should be an investigation, and an investigation that will establish all the facts, including what the congressional leadership knew and what they did when they learned about these things. And, of course, for Pete Hoekstra and Darrell Issa to say Nancy Pelosi's lying and I have a different version of the facts, this doesn't make a case against an investigation. It's just exactly the opposite. It really makes the case for the investigation because we now have, let's put it in the mildest possible terms, we have strongly different recollections about what happened in those briefings and when they occurred and who was present at them. And, we need to have all that information collected and reconciled and form some final judgment. And I think it's rather likely, in my view, that history is going to have some very harsh things to say about the congressional leadership. But I'd also say that, their liability for what happened is pretty peripheral. I mean, frankly, Nancy Pelosi, at the time this happened, wasn't in power. They were the minority, after all. So what she said and did wouldn't have counted for much. As far as I recall, during that period of time, George Bush was not quaking in his boots about what the Democratic minority said or thought about things.
I don't know. I mean, it seems like if I was the minority member of the Intelligence Committee and they told me, yeah, we figured out all these legalities to where we could torture people or whatever, I don't care if they lock me up for something like that. And in fact, I think the Constitution would protect me. Even if I have an oath of secrecy, the Constitution protects me from going to prison for anything like that other than just breach of the peace, right? Why wouldn't I just get on the House floor and say, hey, guess what? They just admitted to me, everybody. They're torturing people.
Yeah, that's exactly right. I mean, there is the debate clause of the Constitution, which provides an absolute privilege for what members say on the floor of the House or the floor of the Senate. And, you know, I got to say, looking back at this, to me it's pretty amazing that, you know, that congressional leaders didn't come forward and say something. But, you know, of course, you know, there's also a question about what they learned and what was in those briefings, and so on. So, you know, I just say we're at a point where it's absolutely appropriate to be very skeptical both about the claims that have come from the CIA, which is trying to cover its posterior, and about the responses that have come from people like Hoekstra, Pelosi, Rockefeller, and Robertson. I mean, I think everybody's trying to cover his or her posterior, and I don't think anybody's giving us a pure version of the truth. That all makes clear that we really need an inquiry to get to the bottom of the facts.
Mm-hmm. Well, let me ask you this, because I know you know a lot about history and all over the world, too. Has there ever been a world empire that didn't torture people?
Oh, you know, I think torture is almost a historical common. You know, it's been involved in societies all around the world for a very long time, and it's really only since about the 18th century in, you know, the European world and North America that we began to see this development of a rejection of torture as part of the Enlightenment. The U.S. took a very, very strong position against it. So probably the best case you can make for a country that embraced the prohibition on torture is the United States.
Yeah, but that only lasted through, what, like World War II? I mean, we've had our CIA goons training other CIA goons in other countries how to torture people all this time, right?
Well, I think there are a lot. There have always been issues about it. And you have to remember, though, torture, the way it's used technically, means the use of these techniques is a matter of government policy. So the fact that somebody's taking pliers to someone's teeth in a police station, you know, I mean, that is technically torture, but our real focus is on when this happens as a matter of policy. The government's officially approving it. And the big difference that we've had lately is the Bush administration essentially legalizing torture, trying to change the understanding of the law to say this is absolutely legal, you can do it whenever you want, whereas before I think it was always in the shadows, questionable legality, people knowing that if they were exposed, they might wind up being prosecuted.
Mm-hmm. Well, I guess I can imagine that your belief is that in order to have a prosecution or an investigation, official, you know, special prosecutor or whatever, investigate this, you know, with a grand jury or what have you, what it would take to have that happen would be the public of this country making it happen. But how do we do that, Scott?
Well, I agree. I mean, I think a sense of public indignation, public demand for accountability is what's necessary for it to happen. And I think this is the reason why Dick Cheney is taken to the airwaves. He's all over the place defending himself, and I think it's because he sees that there has been a pretty dramatic move in favor of formal accountability. He wants to try and head that off. But I'm not convinced that's going to work. But I think public demands for accountability, people writing their congressmen about it, people expressing their concern about it, insisting on the rule of law, and not allowing this to be portrayed as a Democrat versus Republican, red versus blue, liberal versus conservative issue, because the idea, frankly, that Republicans and conservatives embrace torture is ridiculous.
Right, it is. There are a lot of conservatives and people on the right of all descriptions who don't support torture, right?
Absolutely. In fact, the whole movement to bar torture comes up through the Republican Party and comes up on the right, not on the left.
Well, but that was back when the Republicans were the progressives, right?
That's true too. Yeah, I mean it's you
look at National Review. They don't want prosecution. They don't want any law to apply to any of these people.
That's right. I mean, we can also say that the tables have been turned, and the Republican Party somehow has become the party of Jefferson Davis.
Well, and that's something for them to be really proud of too, I guess. All right. Thank you very much for your time, as always. It's great to have you here to help flesh out all these questions for us.
Hey, great to be with you. Good luck.
All right, y'all, that's the other Scott Horton. He's from Harper's Magazine. He's a professor, distinguished visiting professor at Hofstra Law School, also at Columbia. Harper's Magazine, the blog is called No Comment. And we'll be back right after this.